And let me make something crystal clear. I never said Jeffrey Epstein didn't traffic other people, other women, and they're not other victims. This is the investigation we were given from 2006, 7, and 8, and the search warrants from 2006, 7, and 8. That's what we're working with.
Wait, have you released all of the stuff that the FBI has seized from Epstein's house? The computers, the emails, the file cabinets, the documents? What about the financial records? Have you released all of that?
Everything the court has allowed us to release.
Which court are you talking about?
3 separate federal courts have come in and said...
We're talking about the evidence you've got. It's got nothing to do with what those courts have.
Do you have any idea how the law works? Do you want me to break the law in a federal judge's order?
No, I want you to follow your own word, Director Patel. You said up there it was under the direct control of the FBI director. He had the black book.
Everything I have direct control over, we have gone to court. You haven't.
Complete your sentence. Everything you have direct control over, you said.
Have gone to court, and everything we have direct control over.
Complete your sentence. You said everything.
Release. We're releasing.
Much more is.
Silence doesn't mean nothing is happening. Sometimes it means the machinery is warming up. Behind closed doors, in sworn federal filings, former leaders of the FBI are saying something that should stop this country cold. The man running America's most powerful law enforcement agency allegedly admitted he knew he was breaking the law and did it anyway, not by accident. Not out of confusion, but because he believed his survival depended on pleasing one man. This isn't gossip. This isn't a leak. This isn't cable news speculation. This is testimony under oath. And it describes a bureau being hollowed out from the inside, not by incompetence, but by design. According to multiple former senior FBI officials, the director told them directly that agents connected to investigations involving Donald Trump had to go, not because they were bad at their jobs, not because they violated policy, but because they did their jobs too well, because they followed evidence, because they worked cases Trump never forgave. The allegation is devastating in its simplicity. He said he knew the firings were likely unlawful. He said it would violate internal protections meant to keep federal law enforcement insulated from political revenge. And then he did it anyway, because allegedly Trump hadn't forgotten, because allegedly his own job was on the line. That sentence alone should echo in every courtroom and committee room in America. The FBI director, charged with protecting the rule of law, allegedly admitting that he subordinated the law to personal loyalty. That is not a management dispute. That is not politics as usual. That is the definition of institutional corruption. What makes this moment so dangerous is not just what is alleged, but how it's being alleged. These claims are not being floated anonymously. They are embedded in formal lawsuits filed in federal court. The people making them are not junior employees with grudges. They are former acting directors and senior officials, people who understand exactly what it means to put their names under oath, people who know that lying here doesn't just end careers, it ends freedom. And they're not vague. They recount specific conversations, specific admissions, specific explanations for why the purge happened. They describe a pattern. Agents tied to January 6th investigations, agents connected to classified documents cases, agents who touched anything Trump viewed as personal betrayal, systematically removed, not reassigned, not reviewed, fired. Strip away the noise and the structure becomes clear. This wasn't random, it wasn't chaotic, it was targeted. A cleansing operation dressed up as personnel management. That's where the larger danger comes into focus. Authoritarian systems don't begin with tanks, they begin with loyalty tests. They begin by teaching institutions that survival depends on obedience. When law enforcement is transformed from an independent check on power into a personal shield for power, democracy doesn't collapse all at once. It corrodes. Federal civil service law exists precisely to prevent this. You are not allowed to fire agents because they investigated the president. You are not allowed to retaliate against employees for executing lawful duties. You are not allowed to weaponize personnel decisions to settle political scores. These aren't obscure rules. They are foundational. They exist because history taught us what happens when police forces become tools of personal rule. And this is where the legal peril sharpens. If these sworn statements are accurate, they do more than establish misconduct. They establish intent, knowledge, consciousness of wrongdoing. The director allegedly didn't just cross a line. He acknowledged the line was there, explained why it mattered, and stepped over it anyway. Prosecutors look for that kind of evidence obsessively. It's the difference between negligence and criminality, between a defense of ignorance and proof of willfulness. If you can show someone knew an act was illegal and proceeded regardless, you don't have to guess at motive. You don't have to infer state of mind. It's handed to you. And then there is Congress. During his confirmation, the director assured senators that he would not retaliate against agents for politically sensitive work, that personnel decisions would be merit-based, that the independence of the Bureau would be protected. Those statements were made under oath. Carefully, repeatedly. Now place those assurances next to what these former officials say he told them privately. If both cannot be true, and they cannot, then someone lied to Congress. And lying to Congress is not a scandal. It's a felony. Perjury cases are difficult, but this is how they're built. You compare sworn testimony, you establish contradictions, you show that the false statement was material, and you demonstrate that it was made knowingly. When multiple witnesses independently describe the same private admissions, when those admissions align with documented actions, and when the accused has published writings that mirror the conduct, the evidentiary puzzle starts snapping together. Yes, published writings. Because in a twist almost too perfect for fiction, the director authored a book before taking office laying out a worldview that now reads like a blueprint. In it, career federal employees are portrayed as enemies, disloyalty is framed as treason, purges are not cautioned against, they're celebrated. That book is now being cited in court, not as opinion, as evidence of premeditation, evidence that these firings were not ad hoc reactions, but the execution of a long-held agenda. When plaintiffs can point to your own words and say, this is exactly what he said he wanted to do, plausible deniability evaporates. Defenders will argue that FBI directors have broad discretion, that presidents are allowed to appoint leaders who align with their priorities, that staffing changes happen all the time, and in isolation that's true. Authority exists, but it is not unlimited. It ends where retaliation begins. It ends where protected activity is punished. It ends where the Constitution steps in. The Constitution does not allow a president or his enforcers to punish law enforcement for investigating him. That's not separation of powers. That's personal rule. And the danger here extends beyond one man's career, because this evidence isn't sitting in a vacuum. It's being preserved, filed, logged, transcribed. Civil courts are generating records. Congressional committees are compiling exhibits. Witnesses are testifying under oath, while memories are fresh and documents intact. That matters because political protection is temporary. Lawsuits aren't. Congressional records don't expire. Testimony doesn't forget itself. Right now, the director is shielded by a Justice Department controlled by the very administration implicated in these acts. That shield is political, not legal. It lasts only as long as power does. The moment that power shifts, through elections, through time, through history, the protection disappears. What remains is the record. This is how delayed accountability works. It doesn't announce itself with handcuffs. It waits, it accumulates. It lets people believe they've survived the storm, right up until the ground gives way. And this is where the Trump pattern reasserts itself. Demand loyalty, issue orders that skate the law, let subordinates execute them. Then, when consequences arrive, step back. Claim ignorance, disown, sacrifice. We've seen it before. Fixers go to prison, lawyers flip, operatives are left holding the bag. The man at the center shrugs and moves on. The FBI director, if these allegations are true, fits that pattern perfectly. The enforcer, the loyalist, the one who made the system bend. And history tells us what happens to enforcers when the bill comes due. What makes this moment uniquely perilous is the institutional damage already done. Agents fired for doing their job send a message to those who remain. Investigate power and risk your career. Protect power and advance. That chilling effect doesn't require explicit orders. It spreads quietly, efficiently. That's how democracies slide. Not through coups, but through fear. Through self-censorship. Through institutions learning which truths are dangerous to pursue. If Congress changes hands, this case explodes. Hearings, subpoenas, televised testimony, side-by-side comparisons of sworn statements, criminal referrals, not as theater, but as documentation. Each question designed not just to extract facts, but to lock them in. And every answer carries risk. Contradict yourself, and it compounds. Tell the truth, and it implicates. Stay silent, and it invites inference. This is what happens when lies pile up faster than exits. There's an irony here that should not be missed. The very obsession with loyalty that fueled this purge is what makes accountability inevitable, because loyalty demands action, and action leaves evidence. Words get spoken, orders get given, books get written, and eventually, someone decides they won't go down alone. This is not about whether an arrest happens tomorrow. It's about trajectory, about gravity, about the slow, relentless pull of the law once political insulation cracks. The real warning isn't to one official, it's to the system. When law enforcement is weaponized for personal revenge, the law doesn't disappear, it waits. Watch this closely, because moments like this don't announce themselves as historical until it's too late. And if you want to understand how democracies fail or how they fight back, you can't look away when the evidence starts stacking up.